ставит.
Ты,
Единственное,
ты
что...
ти на українському говориш?
Ні, я тільки
Ні.
розумію трошки.
Ну вот немножко ж говоришь, то начни, потому что сейчас парень этот
Да, у
украинец.
меня соседка была в детстве чистая украинка, и она... Я на Северном Кавказе выросла, Наталья. Но поскольку это Кубань, то мы диалект понимаем. Кубанские казаки, они же от запорожских пошли, они украинскую.
Ага, я тебе говорю, что уже она придет скоро. Давай тогда сейчас прям начнем.
Ну, смотрите.
Ты
Вот
готова?
соседка мне все время говорила: ты сможешь понять фразу «дит пасетиля», «дит пасетиля»? И я думаю, что за «дит пасетиля»? Она еще это говорит как одно слово. Вот с детства помню это. Дед пасет теленка, правильно, да? Дит пасетиля.
Да. О, так ты можешь много сказать. Нас чуєте? Оце Катерина, вона, як ти казала, дід пасе теля.
Катруся. В
Катруся.
українській мові Катруся.
Ага.
Так, всім привіт.
Угу.
Видите,
Добрий
все
день,
нормально.
Антон.
Мы все
Да,
нормально друг друга.
Олег. Угу.
у нас з початку повномасштабної війни ми вивчили вже українську мову і зараз ще вивчаємо англійську мову. Ось, щоб це...
Окей, давайте. У нас, як вже зайде Вільям, тоді він на англійське буде, тоді ми будемо перекладати. Джулия, она лоер, сейчас она делает презентацию на английском. Хотите повысить свой English skill, послушайте. Как писать завещание. Как писать завещание. So, we are live on Instagram, and today's lawyer in British Columbia, Julia Barcel, with a lot of experience, will talk to us about wills and law in BC. Hi, Julia.
Hello. Hi, everybody. You don't, like, I guess people who watching it now, they don't see my face, but they see the presentation that I'm going to make and the text and a little bit of law. And I think that's good to see while I'm talking about it. So the name and the idea of the presentation is succession law in British Columbia, just so people understand how it all works, how it all structures, and what people should do and what they should be concerned about. Not concerned, rather what they should deal with during their lifetime. Succession law in British Columbia. The current British Columbia law legislation that is governs wills, estate proceedings, execution of the documents, different documents, wills, and other things, validity and legal meaning of those documents. This is a one piece of legislation, which is in effect only 10 years. It was issued, that was valid since March 31st, 2013. It's called WESA, Wills, Estates and Succession Act. And this legislation combines previous three pieces of legislation: Wills Act, Wills Variation Act, and Estate Act, and brought a lot of significant changes to the law. Why person needs a will? Often I am asked if everybody needs a will. Here's the simple and very clear answer. People don't have to make a will. So the legislator provides the regime under which the succession is handled, under which the estate passes to the beneficiaries of it by law. So who needs to make a will? The person who wishes to change the regime of succession, which is established by law, needs to make a will. Again, a person who wishes to change the regime of succession, which is established by the law, needs to make a will. Essentially, it's almost everybody. And here's why. The simple situation. Married couple with children. Presumably and hopefully, the children are adults. Everybody's grown up and everybody's fine. And then one of the couple dies. If we go by the law, by the legislation, then both spouse as well as children come to be a beneficiary of the estate. And that is not very considerate of the remaining spouse. It's very inconvenient usually because, you know, essentially it's not the children's property, it's this couple's property, right? All of this. So this is why that regime should be changed for the name of the convenience and fairness in some ways, right? So what we usually do in the wills, the spouses leave the estate to each other first, and only after the last of them, children. So this second slide says precisely that. When a person does not have a will, the law determines how a estate is divided, which may be good for the people, for a particular person, or maybe, and in most cases, not very convenient because legislator tries to be as fair as they can possibly be. And that is not taken into account any specific family dynamics or situations or decisions that may be taken in one particular family. Okay?
Mm-hmm.
So that's the situation. However, we still need to understand how the basic division of the estate structured in the law in order to understand whether we need to change this or not. Subchapter 1 of the Wills, Estates and Succession Act describes specifically how estate distributed if there is no will. Section 20 says that there is spouse, no children, everything goes to the spouse. Easy. In that situation, for example, if there is a couple and there's no children, one might think that people do not have to have a will because they don't wish to change the regime that is prescribed by the legislator. They wish to leave everything to their spouse. That is correct, except for one little very sad thing. What happens if they die together? What happens? What happens now by new law that the estate basically cut in half, and half is goes to one side of the family and another half to another side of the family. And for that matter, people should think, right, how they want to do it. Okay, if there is spouse and children, as I said, that is a specific and fairly complicated regime of dividing the estate. Section 21 of Wills, Estates and Succession Act speaks of that. For example, household furnishings and all the household items remains in the house with the spouse as a property of the spouse who outlived the deceased. all the debts and liabilities of the deceased are paid from the estate funds as the first order of business. That's always the situation, will or no will. In our wills, one of the first sections speaks of that, of payment of the debts. Then, if there are children, all the children are common, spouse receives first $300,000 from the estate funds, and then the rest of it divided in half of which receives the spouse again, and the other half is distributed among children per capita. If there are not all the children in common, then first $150,000 goes to a spouse, and then the rest of it divided the same way as I have just described. We should understand also what is included in the estate, and that's, apologies. Sorry. That is also in itself quite a complicated issue because, for example, the property that is in joint ownership goes to the surviving joint owner by the right of survivorship, not by estate rules, not by will rules. The financial instruments, the ones that are possible to specifically designate beneficiary for, such as mutual funds, investments, RRSPs, insurance policies. Usually people require to designate a beneficiary within those financial instruments, and that is not a part of the estate, which is distributed either under the will or either under the Wills, Estates and Succession Act. This is separate thing. However, it's complicated. Why? Because it does not include it in the estate which is governed by the WESA or which is governed by the will, but it is included in the bulk of the estate for the tax purposes. How the taxes go there, I will explain a little later. Next, Section 23 of Wills, Estates and Succession Act describes to us how the estate is divided if there are no spouse, but there are children or other relatives having the right to inherit. First of all, if there's no spouse, children are the first one to inherit. If there are children, no one else inherits but children. If there is no will, in equal parts, obviously. Mind you, the good thing that law provides, if there are several children and one of the children predeceased the parents, which we don't want to happen, but sometimes happen, and that deceased child have children of their own, then the children in that situation come into the deceased parents' shoes and receive their share, which is very specific, determined by the law, but one needs to be very conscious of that part when one drafts the will, because it must be mentioned in the will. Otherwise, only the level of beneficiaries, the first level that is there, will receive the inheritance and not their children. I will explain, I will come back to it a little later as well. So, children is the first. If there are no children, then parents. If there are no parents, then parents' descendants, meaning siblings, brothers or sisters. If there are no parents or no siblings, then grandparents if alive. If grandparents are not alive, then their descendants, first cousins of the deceased. So see how it goes there. For example, if there are siblings get the inheritance. If there are cousins alive and well, but the grandchildren are alive, then the grandchildren are first who inherits before cousins do. And that is a 4 steps. The great parents or their descendants, cousins was once removed. So that's 4 steps, 5 steps, I guess. After the 4th degrees of consanguinity, then there are no relatives who may, without a will, inherit anything. Then there is a escheat act comes into play, meaning that government inherits this property. This is why people who don't have close relatives really should think about writing a will and making their wishes known to the legislator, to the court, to executor, and everything else. So that is, again, same thing, only more specific. Yeah, that's all the same, only more specific for that. Maybe anyone has questions, or it doesn't work like this here. Should I do, I can go on and explain. Okay, understood. If there is, again, if there is no will, section 2635 describes how the inheritance goes. I did explain to you the basic part of it, but there are some specifics that legislator provides for. For example, as I already mentioned, household items goes to the spouse. Family home, if it is not in joint tenancy, which then goes to the surviving joint tenant and is not a part of the estate, if the house is in the name of the deceased person only, right? But it has been a family home, so where the family resided in, then court has a broad discretion as to how to deal with this piece of property and piece of the estate.
Yulia, I have a question.
Yes.
Is this timely?
Yeah, sure.
I'm not sure if it will be relevant enough, but I just want to reconfirm. I heard that in BC, specifically in our province, parents cannot leave a child without inheritance. It's illegal. So like sometimes the relationship work.
Not true.
They can?
Not true. Here's no. They can. However, that's not quite like that. People can write in the will whatever they want. Now, in order to disinherit somebody, all they need to do is just write in the will. I want to divide my estate among 3 of my children, and the other 2, I don't want to give them anything. That's basically what they need to do. However,
just a puss in the high boots, you know?
No, I understand, but those children have the right to contest such a will. Now, the court, while looking at those cases, should understand what happened. What were the reasons? Right? That's why we usually, in that situation, ask the person writing a will, draft a special memorandum which is attached to the will. Why it is done that way? Here's why. Because after the death of the person, will becomes a public document, and not every family wishes to describe all the family dynamics, relationship, and problems within a public document, right? While a memorandum such as this could be attached to the will, but will never become a public document, and those documents only would be seen by the persons who are directly affected by it. For example, it may be that those two children who are disinherited had received from the parents financial help during their lifetime in the amount that it would pretty much constitute their inheritance share. And by doing it this way, parents just restore a fairness among the children. Do you understand what I'm saying? For example, this is one of the situation. There can be that such person is incapacitated or something, and they cannot handle anything, and they're in, long-term hospital or something, and they don't basically need anything. That can also be the situation. There can be that one of the children, say, married to a zillionaire, right? And the other struggling. And by dividing in the way they do, again, parents try to restore a fairness.
But that's only if siblings want to, right? If they are in good on good terms.
That's precisely it. If they don't want to, then there is no one is to question why is that, right? But if they want to, court look closely and seriously at all the surrounding circumstances. The court looks at the financial state and financial situation of those siblings, of those people, and then decide what's fair. What court does is look at all of this and then say, okay, you need to divide it somehow differently, go agree on things. Court does not make those decisions, but it gives directions, and people can always agree on different distribution of the estate among themselves, the beneficiaries, despite what is actually provided by the will. Okay? Answered enough?
Yeah, I also have another one. I'm not sure.
Sure,
I will throw it in, and when it fits through your content, you will work around it. So just for me as a professional working in real estate, and sometimes my clients buy, and I had a deal this year where they buy a property which was sold after it was inherited, but basically my understanding, it was in the process when executor took over the right, and they are doing that in the process. So what is the information I need to be to watch out? What are the red flags that the deal potentially can be delayed? Because we are in a timeline, right? Sometimes client sells one property, they buy another. So we don't want any delays. We don't want any disputes.
Fair question. Easy. Well, you start from a land title search, right? If the property registered to this person as an executor, that's it. That's all you need.
Okay. It's got to be already registered on the title.
Registered in the name of the estate, care of this particular person or persons who are executors or administrators of the estate.
Okay.
If the registration of that part is complete, then you're okay. That's not always the case. Sometimes those things go concurrently. They're finishing, finalizing the estate, as well as already preparing to sell a property, and so the property still can be registered in the name of the deceased. In that case, you need to put the subject, obviously, in the contract, right? So that by the time by the time the deal goes through, or a week before, so 2 weeks before, however much time you want for that, the registration needs to be complete to the executor.
Mhm.
Okay, and that's very important, because without this registration, nothing will go through.
Mhm.
Now, sometimes it just goes minute by minute, in which situation it can be, again, the subject can be the same very day, but you need to check that the grant of probate or grant of administration properly issued by the Supreme Court, which is always Supreme Court, and that's the people that you are actually dealing with. They're going to be executors or administrators, but mostly it's not your deal. Mostly you should just check the title, and it should be registered in the name of the executor or administrator. Okay.
And executor is only one, right?
No, there can be
Oh.
several.
Can be several. And what's the administrator cannot be on the title?
Can be.
Can be.
Administrator is the same as executor. Administrator
Okay.
just the person that is dealing with the estate is called administrator, and giving a grant of administration, provided a grant of administration when there is no will.
Mhm.
But
Oh.
they do the same thing as executor does under the will.
Mhm.
That's the same exact position.
Okay.
Okay,
Fair
that's
enough.
just different. Yeah.
Okay.
Okay, go
If you
back
want more
to
questions, let me know. I'll give you some.
yeah, sure. Family home can be specifically addressed by the court decision. It can be left to the spouse, or spouse can be allowed to buy the part of it from the one that they are not inheriting by law from the estate, and all sorts of things. But again, that depends what estate consists of, right? Like, for example, if the family residence, if the house is the only item in the whole estate, obviously a spouse will not get it. It has to be divided among other beneficiaries according to the will or the law, if there is no will. So that's about the house. Now, that was a general structure of the estate. Now, why do I need a will? Why does anybody need a will? As I already touched on that a little bit, general answer is that when you wish to change the regime prescribed by the law, then you need a will. You also will be able then to appoint as executor and trustee a person of your choice, divide your estate the way you wish and desire, give to charity, leave some personal gifts to your friends and relatives, not necessarily the ones that are mentioned in the law as your beneficiaries, but whoever you wish. And basically just, make your wishes known. A will enables you to determine the distribution of the estate, change in the regime, make gifts for charities, and all of that. In the absence of the will, I already described to you that government by law determines how your assets are distributed and how it is managed. Okay, any more questions at this point?
Yeah, I can ask one more. So trustee.
Yeah.
When people who write a will, what's their proper term, by the way?
Will maker.
Will makers. So if they don't want to nominate guardian as a person managing funds, so they nominate
Not
trustee.
guardian, not guardian. Guardian is for children.
Yeah, but hypothetically, there's a minor, right? In there, they nominate a guardian and they want to nominate a trustee. So is it stays with them just to make sure that trustee is still operational? Like what happens if they basically, if the company doesn't exist anymore?
Well, the worst thing person can do is to appoint trust company to manage their trust funds.
Yeah, but so trust
worst.
company should be operational, right?
Well, yeah, but the worst thing they can do, it's horrible.
It's horrible.
It's horrible. Why? There should be a person. Why trust companies?
Well, if they don't have anybody to nominate, if they know that the guardian is not savvy with the funds.
Well, yeah, I guess. Well, no, of course, a company should be operational. And then if it isn't, it's a problem, obviously. Yeah, absolutely.
Well, yeah, I guess that's a fair point, especially for immigrants, right? If you don't have anybody, like, why would you hand over your own money to a person who's not a family, even to a relative sometimes, like my accountant says, it's cheaper to deal with strangers than with relatives.
Well,
Not always
no.
that.
And plus, you know, a trustee, even not savvy, I know, I understand. It's sometimes problematic. Yeah, I understand that. Yeah. Can't decide, make all the decisions and can't make everything perfect, unfortunately. Well, again, the existence of the will makes it much easier for people who left behind. First of all, they know what you wanted. They in terms of everything, the process, the distribution, all sorts of things. And that is all while they're grieving and vulnerable, and actually they lost somebody that they love. And, you know, when there is a will, it is easier for them to deal with it because they feel as they're fulfilling your wishes, which is true, they do. And they feel, you know, sense of accomplishment in some ways. And it makes it much easier to make all the decisions because those decisions are determined by your will.
Julia, I have a questions about rentals. We came across situation when suddenly landlord passed away, and even having authority to leases, we were stopping from renting out the places, which was a huge issue for people that inherit because they could not pay the monthly bills. But how you suggest in this situation to people remember about if they are landlords?
No, but I don't understand why the rental stopped. It should have, was there a will?
The lawyer was scared and were not allowed to anymore access the property or show it, and it was a big deal. The children.
I am so sorry, but it is completely stupid. That's just wrong. Business as usual, nothing goes on. You can sell it, but you can rent it. Moreover, you should rent it. Again, listen, their right to distribute the estate and the right for the execution of the estate is given by the will, not by the court decision. Court only checks if will is made properly and if there is anybody who is disinherited improperly. That's all that court does. So while that's going on, it can be especially if there is if the property is occupied and there are renters there, that just goes on. There may be short period of time before the grant of probate is given if the previous rent is finalized and the other one is, and this grant is not yet issued by the court, that can be a little bit of a lack, of authority to sign. But it may be several months, not much. But generally speaking, it should be as it should be. It should go on. It's just wrong not to do it, because the state, while in the process of probate, should also be making money if possible and operate as a all normal business, and normal life should go on. For that, there is an executor. Okay. Very, very important. If there is no will, it leaves the door open, so to speak, for involvement of outside individuals or organizations into your affairs. For example, if you have minor children, then their interest in your estate will be overseen by Public Guardian and Trustee, the organization established to protect the right of minor and disabled children. That is why when people have minor children, they really, really should make a will. They need to appoint guardians to take care of their children, and in order for the Public Guardian and Trustee not to be involved in this whole affair. Because if there is no will and minor children are beneficiaries of the estate, together with the spouse, with the remaining spouse, you know what happens? Government really takes that money for a while until the children are 19, but it can be, for 10 years or 5 years or 8 years, depending when those children become adults, right? But all that time, those funds sit there with Public Guardian and Trustee, not invested, and just diminishing their value day in and day out. We all know this. So when there are minor children, it's just absolutely imperative to do this, to make a will. Will also enables you to declare your wishes. You don't have to always divide everything equally. There are different situations within families, and you can be as creative as you can possibly be. You can also leave specific things to specific people. For example, so you have one daughter and 5 sons, right? And you are a woman. So you want to leave your jewelry, for example, to your daughter, and the rest of the estate divided among your children. Or you have very close friends and you want to leave them something, a piece of art, a piece of jewelry, some things of a sentimental value, which is impossible to do without a will, right? So those things has to be also understood. Also, you can determine and make known within a will your wishes in terms of your funeral arrangements. That's important to many people with a religious affiliation and stuff, or some sentimental ideas that they want to come to fruition while after they gone from this life. Under the law, as I said, your children are equal beneficiaries, but you don't have to do it. Funny thing is, always wanted to mention it. You real estate agents and most people who listening to me, so you dealing with people who do have property and assets, and then they're not poor people for the most part. But sometimes older people who don't have much ask me, well, why do I need a will? I have like $15,000 in the bank. That's all I have. And I have one son or one daughter. And I am alone. Why do I need a will? Seemingly you don't. Because you do not want to change the order prescribed by the law. Your child will get everything. Here's where the sticky point. Banks, as I already mentioned, the right to the inheritance is created by the will, not by the court decision. And it is up to the financial institution or organizations that hold this title to allow the will to come to fruition without probate or demanding the court order. That is why when there is a small amount of money, say $12,000, $15,000, most banks, up to that amount, I'm sure all the banks allow to will to be executed and the estate divided or paid out only on the basis of the will, because they understand that the cost of the probate proceeding is in that situation is prohibitive. It may be a third of what's left in the estate. That's kind of stupid. And if they see the will, if they understand and this is the only person, sorry, the only child of the deceased, there's no problem. Now, same situation, same exact situation, no will. Now tell me, how bank would know that this deceased person didn't have more children? They wouldn't, right? And so with the same small amount of money, with the same $15,000, the court says, the bank will say no, not gonna give you any money because I don't know who are you, whether you have or deceased person had any other beneficiaries or spouse or children or somebody else. So go to court, bring in the decision, then I will pay out the money. See the difference? Same exact situation. Seemingly, you shouldn't need to have a will because the process is the same. The distribution is the same. But in fact, practically, you need it even more. Because this way, you can save yourself all the hassle of going to court and applying for probate. Okay? Interesting thing for the owners of small businesses. Mind you, that pertains only to the situation when the business is fully 100% is owned by the person that is making a will, right? In that situation, we can, it's the newest practice, although it already is in effect about 5-6 years, and it flows right from what I just mentioned, that right to the inheritance, to the execution of the estate, and to receiving the inheritance is created either by law or by the will, not by the court decision. And there, because BC Corporations Act does not require probate or administration grant in order to transfer the shares of the company to the beneficiaries of the estate. But the other part of the estate of the person, such as real estate property or more substantial financial holdings, are required to be put through probate. We can divide the estate of a person into two parts and write two wills. One that deals with the personal holdings, and another one dealing specifically and only with the business, with the corporation. That way, corporation never have any hiccups in its actions, so it keeps going. No problem there, no breaks or anything. And even more interesting thing, that the value of the shares of this corporation is taken out of the probate fee estimate. What it is, I'll tell you again a little later. Or maybe I can mention it now. The probate fee is 1.4% from the estate value as determined by the statement of assets and liabilities, which is filed with the court as well. There's lots of things there that we can go in deep how to determine the value of the real estate property. Well, how to determine the value of the financial holdings? Easier. We have documents from the bank, right? How, for the purposes of administration of the estate, you would determine the value of the real estate property? That is a very strategic and tactical question, because that depends on what are the plans to do with this particular piece of real estate. If, for example, it's the house or an apartment which is a beneficiary planning on receiving and residing in, they can mention they can mention the value of the property as determined by BC assessment. No one is to question that, because it is determined by BC assessment. We all know that it is a value that, generally speaking, and correct me if I am wrong, you know better, probably 15-20% at the very least lower than the market value of the property. Am I correct in a percentage, Natasha? About 15-20% lower than the market value, right? Right. But if the estate is planning on selling this property later on and dividing the proceeds of this among the beneficiaries, then the property value should be mentioned and put in the documents at the very high end of the market share. Because this way, while you will pay 1.4% of the probate fee as the probate fee to the courts, to the Minister of Finance, you will save on capital gain taxes. Because from the date of the death of the person until the date of final distribution, there is a virtual body that is called estate of somebody, right? And that virtual body owes taxes just as normal person would, except that virtual body does not have exemptions that real person would. And they don't have exemption from the capital gain for the primary residence, because it does not have primary residence. See my point with the capital gain taxes there? So that should be strategically planned while you making those submissions. And as that was after I explained to you about the double will thing, which is one more thing about the double will here. The only difference between those two wills should be one very specific one. There cannot be the same executor, because the executor, while doing the application, while making the application to the court, sign an affidavit that he or she or they disclosed everything that came in their possession as the executor of the estate. And so if they are also executor of the second will, then it just loses the whole idea and the whole value of it. That's the reason why the executors should be different. When one should make a new will or update a will. Having children, acquiring property, changes in family status, physical health, yours or your family members, significant changes in your financial situation, death of any of the executors and trustees or beneficiaries, or mental incapacity of such individual, and many, many other circumstances. Why also it is a very good idea to make a will when there are children, when there are minor children, except for appointing a guardian to the children and trustee for the funds. We also often, more often than not, practically all the time, making a what is called testamentary trust. Because, for example, you're a person of means, say, right? And then you have minor children. You hope you will grow very old and you will see your grandchildren and great-great-great-grandchildren. But you making a will for the unforeseen and unfortunate circumstances that may happen to you while your children are still minor. And in that situation, you don't want to 19 years old person receiving all of your estate, say several millions, several apartments, several houses or businesses, and going crazy, because they inevitably would. Therefore, what is done is testamentary trust, meaning the schedule when and how the children would receive the inheritance. Say 19, 10%, 21, or after the acquiring bachelor degree, another 30%, or also, and the rest of it later, 25 or 27. That's very important to understand and to know, right? You also have to protect minor children, well, from that, and by virtue of appointing proper guardians for the children if something were to happen to you, so that government is not in on a decision who should take care of the children, right? Any questions about that? Anyone? Okay. Very, very specific situation, which is definitely determines a necessity, serious necessity of drafting a proper will. That is, if anyone of from your beneficiaries is of limited or impaired mental capacity. That's a separate issue. If the protection for the beneficiary is not limited to minors only, there can be adult persons with limited capacity or incapacitated, disabled, or ill, or maybe, suffering from some other afflictions, such as substance abuse and stuff like that. There's a lots of situation when they just don't want to divide your estate outright, at least for one of the beneficiaries or some of them, but create a trust which would be governed by the appointed trustees with a specific rules and terms of this trust. That is a difficult and complicated topic, which I will not be able to explore fully today for sure, because we actually close to the, like it's been almost an hour. I can certainly go more. And yeah, that is just, again, going back to the law. If there is no will, if persons, just wanted to mention that, if spouses die together, that rule of 5 days of survival goes. So for example, if they not die together, but they die within 5 days of each other, which can be as a result of some accident or something, then it is seen as if they died together, and the estate divided in halves and dealt with this way, so that there is no need to process one estate after the other. When we do the wills, we usually extend this period of time until 30 days. And when I do wills for very old couples, for very, very for elderly people who had been together for many, many years, we can extend this period of time to 60 days, because we know that old people, when lose their spouses, they very often go quite soon thereafter, just because this is really a traumatic event for them, and that's the main point in their life would be gone. So that's the rule of 5 days survival. Each deceased outlived each other. That's like how law puts it. Joint assets not a part of the estate. Posthumous birth is important as well, because the children who are born after the death of the deceased, they are also the same beneficiaries as they were alive, as if they were alive prior to their death. The will should be executed by law in writing. It requires 2 independent witnesses. It requires determination who would be executor and trustee, who would be dealing with this. It requires to determine who are the beneficiaries, debts and gifts in the will, specific bequests, as I explained, debts and gifts during lifetime taken into account while creating a will as well. You can forgive them, you can consider them and a part of the future estate. That is up to you, the will maker. As I already explained, the estate comprise separate property for the will and for the court proceedings. For taxes, everything else, even a part of joint property, even the financial instruments that are designated specifically outside of the will, they are part of the estate. Now, the last thing that I'm going to explain right now is a little bit about taxes, because many people ask for that, how that works. I want to explain to people what taxes come into play in that situation. Now, in British Columbia, we have a source system of taxation. There's only salary, business, or capital gains are taxable incomes. Nothing else, not gifts, not inheritance, not went on the street, found a bag of money, none of that is taxable. That does not mean that the state does not pay taxes. It does, because once person dies, the virtual entity, as I already explained, comes to life, the estate of the deceased person. And after the process is complete, the executors or administrators must file 2 tax declarations. One is for the last year of the deceased's life, and that is exactly how it would have been if that person were alive. And the second one from the date of the death until the date of the final distribution. There, it would be the same. It's virtual entity though, so the only difference is that this entity does not have exemptions that physical alive person would have. So, except for the will, we have, well, who can dispute the will? I already explained. Spouse, I think I did. If I didn't, only 2 categories of people, spouses and children. And a dispute, it goes by court application. So I can talk about power of attorney or finish altogether. What should I do? Natasha.
Us about power of attorney, yeah.
Okay. I will, sure. Except for wills, like people often confuse those 2 things. What people should understand that a power of attorney and a will divided by the time, by the line of life and death. Power of attorney lives and dies with the person, while will is meaningless until person is breathing. So that's what it is. Now, power of attorney is a very, very important and necessary instrument to have, because if we or somebody that we know or somebody close to us loses their mental capacity and they don't have a power of attorney, that can cause very, very severe consequences. It may be really expensive because nothing can be done. Everything is in limbo if the person loses mental capacity and they don't have power of attorney. So when couples come to me for the wills, I always convince them to make also a power of attorney. Again, that there are 4 different types of power of attorney. There's general, there's enduring, there is springing, there is and there's specific. What I usually do is power of attorney that's enduring, meaning that it endures subsequent mental capacity on the part of the donor. That's what it means, actually. And also, for you, it is specifically important as real estate agents that in my powers of attorney, many others, we exclude validity of exclude section 56.1 of Land Title Acts, which limits the validity of power of attorney to 3 years. In my power of attorney and many others of my colleagues, we exclude the this paragraph of the law from our powers of attorney. So this document becomes valid infinitely until the donor is alive. So that's the power of attorney. There are other things. There is a presentation agreement which determines a lot more than power of attorney, but that's a separate issue, I find. And there's a living will which deals with the end of life decisions. Well, I guess for the presentation that would be all today. I am willing to answer some questions if there are some.
Thank you so much. So the power of attorney can be combined, all 4 of them in one, or?
No, there's no need to do all 4. There are different types. General, for example, not enduring, stops stop being valid if person is incapacitated, which beats the purpose in my book. But nevertheless, more if you don't put the in the power of attorney section about excluding section 56.1 of land title acts from this document, then in 3 years it just stops being valid altogether for the real estate purposes. That's general. Springing power of attorney is valid after 2 psychiatrists determine that you are no longer capable of making your own decisions and you lost the capacity, and only then such springing power of attorney is valid. Specific power of attorney is given for a specific transaction or a specific property or a specific period of time. And what I usually make is enduring power of attorney non-specific, which is valid forever until the donor is alive. So that's what 4 types of the power of attorney I was talking about. Okay, any more questions?
Yeah, quick question, Julia. So
Yeah.
what's the process of filing? Sometimes I hear that people fill in just online forms and they file themselves. What are the implications of that?
Filing where? Filing what?
Well, I believe my understanding is, again, I'm not sure what's been done, but they say certain steps, there's a filing process. So you,
Filing what, Kate?
I don't, well, I believe there is in Canada, in BC, individual can fill in existing template and just
For what?
formalize it certain way.
For what?
And
For what? I don't understand what you asking.
for power of attorney.
God forbid, no. Power of attorney should be signed. The signature should be certified by notary or a lawyer. Otherwise,
Or
it's not
witness,
valid.
right?
Well,
Or
no notary or lawyer will witness the power of attorney that is not theirs.
But
just-
why templates exist then for the public? You can even buy them in Staples. What does that mean?
Yeah, you can, but you don't know what again you sign in there. Because there are different things, you need to understand what exactly you're signing. No, some notaries probably would sign this as well, just, take their whatever, how much money they take for power for the certifying signature and do it. They do exist, obviously. There's but you need to understand what it is that you're signing. Would you taking a look at this? Well, I just explained there are 4 types, right?
I'm not the person doing it. I'm just saying I hear that.
I know.
Refer to that.
I am just saying that person, if they know what they're doing, sure, no problem. But it has to be witnessed by notary or lawyer, like notary, and the lawyer also in their capacity as a notary. So yeah, absolutely. Will's template also exists online. And I'm not saying it doesn't necessarily, it doesn't work. It may work. It maybe in many cases it may work. But when it doesn't, then it causes real problems. People often don't know what their problems are. And they don't know what should be done within the will. They just like, oh, that's very easy. I only need to leave it to this my son or this my daughter or to my spouse, right? But then they forget about the children from previous relationships, living in different countries and all that kind of stuff, and that it creates a huge mess. So you need to, at least receive a consultation and then do whatever it is that you need to do.
Thank you so much, Julia. And also another topic, so to speak, usually people are selling their property when they are separating or divorcing, and
Right,
around
right.
this
Family law issues. Yes, I can do that.
family
That's
law.
another area of my expertise. Yes, I do two things. I do family law and I do succession law. Yes.
Mhm.
Mhm.
So if you can join us on one of the Tuesdays for that topic, would be
Oh,
great.
absolutely. Absolutely. Yeah. Yeah. No, I have presentations as well for that. Absolutely.
Mhm.
We will do that as well. Yep.
Yeah, thank you so much, and we will put it on YouTube.
Thank you.
Julia. Thank you. Have a nice day, everybody.
Everybody have a nice day. Thank you very much. Thank you for being here. Natasha, so how many people do we know? How many people were watching us? Just for interest sake?
We have about 20 people on Instagram, actually. Yeah, so
Nice.
quite a few too. Yeah, and then we will put it on our Facebook groups as well after. So there will be more people see it. Yeah.
And by the way, my those presentations are on my website, in my on my professional Facebook pages also, and they're both in Russian and in English.
Yeah, we can do also in Russian or Ukrainian.
Well, no,
Uh,
not Ukrainian. I understand
cannot
Ukrainian can speak it, but yeah, I
Mhm,
think Russian will do.
mhm.
Okay, thank you very much, everybody.
Thank you.
Bye.
Bye bye.